there's 22 total, so I made good progress. I think I've at least started on the ones I got yesterday. I finished the ones I got yesterday, obviously, but anyone who sent it before yesterday, I finished yours for sure, and I've started the ones from yesterday. Okay? So if that one group will send it to me again, resend it, that would be good. Okay? Anything on your minds before we resume? Okay, I asked you at the end of class on Monday about Kentucky law on this issue of resistance. What does it say? What does the KRS say about the issue of whether resistance is required?
In the 510.010, it says physical resistance on the part of the perpetrator shall not be necessary to meet this definition.
And what does this definition refer to?
Says forcible compulsion.
Of forcible compulsion. Okay? So on the one hand, if you're the prosecution bringing a case under Chapter 510, you do not have to show, it is not an element of the crime that you have to prove beyond a reasonable doubt, that there was physical resistance on the part of your complainant. Okay? On the other hand, why did I call your attention to 510.020 subsection 1? Now, what in there might change the outlook or the calculus or the way a prosecutor looks at the physical resistance issue?
Well, it says whether or not it's explicitly stated, it's an element of every defense that the sexual act was committed without consent.
So, physical resistance is not an element. It says it right there as explicitly as you could hope for in 510.010. But, maybe but is not the right word here, although I think it is. It is an element that the act was committed without consent. Or non-consent is an element. Okay? What is the relationship, or how would it change or affect the way you would look at a case as a prosecutor, knowing physical resistance is not an element, non-consent is?
So physical resistance is different than maybe giving other outward indicators that might show that the person was not consenting.
I'm sorry?
Physically resisting is not the same as giving other outward indicators of your behavior or words showing that you're not consenting.
If this is telling you, oh, I don't need evidence, injuries, scratches, wounds, etc. I need evidence of physical resistance. Technically. So let's say in a situation in which you, prosecutor, don't have evidence of physical resistance. Maybe the complainant even says, I didn't physically resist out of fear, out of shock, etc. Okay? So, or at the very least, even if the complainant does say she resisted, there's no physical evidence of it, right? That you can point to corroborate that. But either way, you don't have evidence, maybe even not the complainant's testimony of physical resistance. Which direction, in terms of your decision whether to bring that case, which direction is this pointing you in?
To find define consent.
I'm sorry?
Define consent.
Don't worry about consent right now, just if you don't have evidence of physical resistance, 510.010, what effect would that provision have on your decision? I beg your pardon?
That could be evidence that there was force and threat.
Now, you don't have evidence of physical resistance. Now, you're missing the question, what I'm trying to get at here.
I would bring the case.
You might still bring the case because you don't need physical evidence, right? So, at least as far as 510.010 is concerned, the fact that you don't have evidence of physical resistance wouldn't be a barrier, because the law specifically says you don't need it. It's not an element. It's not a requirement. So on the one hand, 510.010 is pushing you to say, or might lead you to say, that will not prevent me from bringing this case, because I can tell the jury and the judge will instruct the jury that physical resistance is not required. But what about 020? In the same situation, same assumption, you don't have evidence of physical resistance. What might 510.020 cause you to think?
It might cause you to think that you can't bring the case to trial because proving that there was not consent is easier said than done.
Because while it's not an element, and that from the prosecution's point of view is good and makes this not a barrier, you still have the hurdle of showing non-consent. And while it's not absolutely required that you have physical resistance to show non-consent, you're going to have to confront the challenge. How do I convince the jury that there was non-consent despite no physical resistance? So it's the difference between an absolute requirement in the law, because it's not an element, so it's not a requirement that the prosecution show it beyond a reasonable doubt. It nevertheless becomes a practical consideration, because this may make it harder, not impossible, but harder to show what you do have to show. And I want to really emphasize this to illustrate the difference to you between absolute requirements, elements of statutes, and practical considerations about what you think you can prove even when they are the elements. That these two are not disconnected, in other words. They're connected even though this is the requirement and this isn't.
Personally, I don't like at all the second one, that it's an element. It's an element that actually something without consent, because I feel like then I don't like that the burden is on the prosecutor to prove there was not consent. I'd rather it be the defendant has to prove that there was consent.
And we will talk about the difference between that being a element of the crime, that is, the prosecution will show beyond a reasonable doubt a lack of consent, or, on the other hand, putting the burden of proof on the defendant as an affirmative defense to show there was consent. It's a huge difference, and it may raise due process issues, and it may raise effective prosecution. Can there be effective prosecution issues? All of that.
So when you have no actual evidence other than he said, she said, and let's say both testify, is your only option in questioning to ask the defendant, like, did you not have consent, but did you have consent from this person, and how did you have it, and just hope that the jury...
Well, there is no doubt that credibility determinations are within the province of the jury, and who come in those cases. What makes a witness credible becomes really important, and juries have enormous discretion. Remember, what's the appellate standard of review in all cases of jury verdicts, not just sexual assault cases? It is, was there substantial evidence from which the jury could have reached its conclusion? So if the jury finds the defendant guilty, their credibility determination that the complainant was credible and or that the defendant wasn't is not going to be reversed. So the jury has that enormous power. And what will make, if you're a prosecutor, you're trying to think, what will make the complainant's testimony more credible? it's gonna be as credible in one sense as he or she is on the stand. Do they come across believable? Is their account consistent from prior statements they made to the police, for example? Or a huge issue in many cases is, was there a contemporaneous report? Or did they wait a long time, right? If they wait a long time, defense will be able to undermine credibility. Was there a physical exam that shows bruising, for example, that is consistent with non-consent? That can support the credibility of the complainant. Was, if they didn't report it to the police or go to a hospital or a trauma center, did they talk to anyone else? A confidant, a friend, a relative, right? That can bolster credibility. All of these things. So if we're assuming that there is not physical evidence, then anything that goes to the credibility and consistency of either witness, assuming we're, in the pure case of just two witnesses, he said, she said, that credibility is going to be critical. But I will tell you, prosecutors are in most jurisdictions, and we can talk about whether this is justified or something that should be criticized. They are very reluctant to bring those cases because they are afraid they can't get convictions because of the burden of proof being beyond a reasonable doubt. And that could be a reason we might want to shift the burden of proof. Or maybe not, depending on our point of view. Okay? So I raised this. This is where Kentucky law is. And 510.020 subsection 1 and its focus on without consent makes this at least a relevant consideration for prosecutors thinking about whether they can show it was without consent. It's not dispositive, but it's relevant. It's going to be relevant inevitably. Okay? So let's talk about Barnes. Tell me about what happened between and the relationship between Marcia and the defendant Barnes.
So Marcia went over to Barnes' house. I believe they were neighbors, and
They had been neighbors, I think. I don't think they were.
Okay.
And they had known each other for a while.
Yes.
They had known each other for a number of years. And all of this led up to his arrest in 1982. She had once bought pot from him, and that becomes wrapped up in this incident. So what happened on May 27th?
May 27th, Marcia went over to Barnes to purchase marijuana, but did not.
From her point of view, is to purchase marijuana.
Yes.
How did it come about that she went over to his place? Did she just take the initiative and go over to his place for some pot?
I think it was they met somewhere earlier and discussed it.
You called her, right?
Mr. Lamb?
Sure. I think Barnes' family had just come into a sum of money and they were celebrating.
That's right.
So he was having drinks and had invited her over to come drink. She declined, and I guess he kept kind of heckling her to the point where later in the evening, finally, she said, "Okay, I'd like to come over and buy some marijuana."
Right, so he calls, he wants her to come to this celebration, drinking. She's like, no, he calls twice, and finally she agrees. And her reasoning is, I don't really care about your family celebration. I want to buy some marijuana. So there's already, they're acting at cross purposes. They have very different agendas, it appears, from their actions. And she doesn't get there until 1 in the morning. She doesn't get there until 1 in the morning, and she's like, I just want to buy the marijuana and go home. And instead he says,
He doesn't let her leave, and kind of starts coming on to her.
and first he says, it's cold out here, so let's go inside.
Right. And it
Right.
took a couple attempts to try.
And you're a prosecutor.
Sure.
You're a prosecutor. Let's assume that part is agreed on. That both testified that, yeah, she came over, said she just wanted to buy the pot, and I said, oh, come on, it's cold, let's go inside and take care of that. How would you, in your opening statement, saying, we will show evidence that this occurred. How would you try to spin that in your narrative of this case?
That might allege intent.
In what way? Because you gotta explain to the jury the connections you're gonna make. So how would you do that? How would you say, that little snippet? I'm isolating, I could isolate any number of snippets, and we will as we go through this case. How does that snippet fit the narrative you're gonna paint of Barnes?
Because the whole reason for Marshall being there was a short transaction that could have been dealt with outside. He could have just walked outside,
Good.
and he decided instead to extend the time that they were together by.
And what does that show? What word would you use to describe him based on those actions? Mr. Baker?
Yeah, he's just setting a trap, right?
Good. Right, this shows he's manipulative. He's trying to situate her in a way that he can take advantage and accomplish what he has set out to do. He wants to have sex with her, and the manipulation begins almost immediately upon her arrival. So you as a prosecutor, and the defense will tell a very different story, right? He's just being friendly. He was extending the invitation. He called her to have this celebration, come over for drinks, and he wanted her to come in for drinks. So innocent explanation. So part of your job as a lawyer at trial is to sort of piece the facts together in such a way that they fit a story that you want the jury to understand, to perceive the facts as fitting together in a certain way, leading to the conclusion you hope that they will agree with, right? So in every fact, you have to think through, how does it fit that story? And if a fact is inconsistent with it, how do I explain that, right? So you want to thoughtfully go through every fact. And I mean, we're looking at these cases at the other end of the tunnel, after they've been tried and when they're up on appeal. But I want you to also think about it as you read them. How would I have tried this? Given the facts that are described here, and depending on which side I was on, how might I have tried this to try to reach the verdict that would best serve my client, whether it's the prosecution or, in this case, Barnes, whoever the defendant is. Okay? All right. So she ultimately agrees to go inside. Barnes might say that's a manifestation of consent, or at least it's one indicator that she's going along with his suggestions. And she's going to say, or the prosecution's going to say, it's because that's how she could get the transaction done that she came there to do. So what happened once they got inside?
I believe they did smoke a little, and that's when Barnes was starting to make passes at her, hugging her without any like sort of warning, and then in response to that, Marshall tried to leave a couple of times, and Barnes made it very difficult for her. He started yelling. He started flexing for some reason.
That comes a little later, right? She tries to leave. At that point, he says only when she tried to leave did he become unfriendly. There were advances, but it was not in a what she calls later a psychotic way. When she tries to leave, he was ranting and raving. And as she leaves, she reaches the front gate, or tries to leave. She reaches the front gate. And what happens when she reaches the front gate?
She is not able to leave, and
because she can't figure out how to open it.
Right.
And this must have been some atypical gate.
Yeah.
Because most gates are fairly simple, but maybe there was something about this gate that he had for security reasons, or there's a code. But for whatever reason, she could not open the gate, and she asked him to do so, and he didn't. He said no. And at that point is when he reared back as if he's going to hit her, raised fists, and she says she felt threatened by these gestures, and still he refuses to let her leave. She asks, and he refuses to open the gate. This went on for a really long time, 20 minutes. And eventually he said he was going to let her leave, but needed to put his shoes on first. This is, again, according to her testimony, right? Why he needed his shoes to open the gate is a mystery, but that's what it says. So what did she do?
I believe then she came back inside the house.
She went back inside the house with him. That's when he started flexing his muscles, got more and more threatening. She said then they were there for 40 minutes. So 40 minutes more, 20 minutes at the gate. We're talking an hour at this point, just from the time she went out to the gate. And after 40 minutes, again, he started hugging her. She was afraid of him. And what did he do?
I believe. Thanks, Earl.
Anyone? What happened then?
Well, she was looking at the door, and he was like, "Why are you looking at the door?" And just that's when she started to feel even more threatened. And he started apologizing after yelling at her. Said she asked if she could go to her house to hang out, kind of like to try and make it seem like she was okay with him yelling at her, and tried to invite him to come to her house. And he said, "No, my parents aren't gonna be here for a while." And they started, this thing that escalated.
A little louder.
They started to kiss.
And he told her to remove her clothes, right?
Yeah.
He told her to remove her clothes, and when she refused, he reacted by saying, "You're going to upset me." Again, if you're the prosecutor, you're going to say, how could that not be threatening? You're going to sort of portray that. You know, what was the likely tone of a statement like that? You don't want to upset me, right? Well, you know, what are the consequences of that? The tone is likely to have been threatening. So she complied, and they had intercourse. And she said she did that because she felt if she refused, he would become physically violent based on all the things that had happened between them. What happened after that?
After that, she actually spent the night because she couldn't leave.
Is that right? She's
She left it, or she woke up at 4 a.m. and then she got him to walk her to the front gate.
And she finally convinced him to actually open the gate. And what did she do after she was out of his presence?
She called Kaiser Hospital to request an examination, and she referred to the sexual trauma center.
Right, so there is contemporaneous reporting, as we spoke about with Clements, that tends to bolster credibility of a complainant, of a victim. So those are the facts as the prosecution portrays them. What does the defense say? And what is the claim that comes out of the defense's view or version of the facts?
They said that the sex was consensual, and pretty much everything up until they got into the house was the same, but then his version of it, he said he didn't get in an argument with her or threaten her, and that she started taking off her clothes without him prompting her. So he was basically disputing whether or not it was consensual. And then she said he tried to call her a couple of times and she hung up on him or didn't answer. And then he said that they did talk a couple of times afterwards.
And he said, I did not threaten her in any
Yeah.
way. All of this talk about his flexing his muscles, telling her she was going to upset him. All of the testimony he completely denies, said made no gestures, did not force her into anything. All right, so those are our competing views of the facts. What does California law provide on this? There sort of ends up being some confusion here, ultimately, as the courts try to deal with this law. Why is that?
They had an amendment that took out a bit about resistance. So it says by means of force, of fear, or immediate and unlawful bodily injury on a person or another. So that for fear, I think, is really important here.
And that's the new law.
Mm-hmm.
Under the old one, the old law had been the law that the California Appellate Court had applied, the unintermediate appellate court. They had relied on this case, if you look on page 940, case Nash, that had applied the old statute. And the old statute required resistance. And the resistance had been overcome by force or violence, or threats of immediate bodily harm, right? So we know the intermediate appellate court got it wrong because they're applying a case that uses the old statute that has been replaced, has been amended. Since it required resistance, it said, well, she didn't resist, and the intermediate appellate court overturns Barnes's conviction. Okay? So the California Supreme Court is going to use the new law, the actually applicable law, and trying to decide this. And we're going to start with the California Supreme Court telling us why the legislature eliminated physical resistance. And in this sense, California is a lot like Kentucky. Why eliminate the physical resistance requirement? What does the California Supreme Court say about that? Mr. Smith?
I didn't capture it.
They talk about how victims are injured more often when they resist.
So
than when they don't.
the harm to victims
And so prosecutors.
if they do resist. So that's the first element of bad public policy. All right, bad public policy. Imposing a physical resistance requirement subjects victims to the risk that they will be assaulted, that resistance will be met with dangerous force, the use of a weapon, right? That this is bad policy. We are eliminating this requirement because this is what happens. More often when there is resistance than when there's not, there is this danger to victims. Why else? Baker?
So studies have shown that there was psychological infantilism, so fight, or freeze, fight, flight, or freeze kind of reactions to trauma.
The legislature had testimony before it, psychological studies, and anecdotal testimony that, look, you shouldn't have a physical resistance requirement because it's perfectly reasonable that for some victims, they will not resist, but instead will freeze. And that freezing reaction, which is psychologically shown to be common, would prevent resistance. And so if that is a reasonable, typical reaction, then imposing this requirement ends up resulting in some cases in which there was not consent, in which force may have been used, intimidation and threats may have been used, causing somebody to freeze, not resist, and we call it not rape. And the court and the legislature decided that's a reason in public policy that we don't want to impose this resistance requirement.
The resistance requirement also led to prosecutors being unable and unwilling to file cases.
Right? Prosecutors, as we've talked about, prosecutors knowing they have to show physical resistance say, in the absence of evidence of that, I'm not going to bring this case. And we said, look, even if you eliminate the requirement, it may still be a barrier because it may make it harder to show a lack of consent, but at least you're lowering the barrier to prosecution. You're not eliminating it, it'll still be a consideration, but if it's not a requirement, at least more cases might be brought. And the legislature thought more cases that should be brought. You could argue against this amendment by saying, yeah, more cases will be brought, but there'll be cases that lack merit. And that would be the argument you might make against this proposal, but that argument did not persuade the California legislature. Okay?
And findings indicate that resistance has a direct correlation.
Findings indicate
That resistance has a direct correlation with deterring sexual assault, but not thwarting it,
but not.
not preventing rape.
Why would that one perplexes me a little bit? if physical resistance deters rape, then wouldn't you want that to encourage physical resistance? And the legislature might say, we want to encourage physical resistance by keeping it as a requirement in the law. I mean, that's an argument you could make if you were opposing this proposal. How would you answer that? If we take as a premise that physical resistance will deter some would-be rapists, why would you not want to say, let's encourage that and thus deter some sexual assaults?
I would say that the cons or the pros of eliminating the physical resistance requirement outweigh the cons.
Okay, that's one answer you could give. I like it. What else, William?
Because you wouldn't want to criminalize the choice that the victim made in that instance.
We're not going to criminalize it. We're not going to throw her in jail.
Oh, sure. I mean, but, throw her into question in court because...
I like the direction you're going. Another way to put that, I think, would be we don't want to eliminate the possibility of prosecuting a defendant because of that choice.
Maybe
so I
the word
flip it.
Penalize would have been better.
Good. Okay? So the court goes through this and says, look, the legislative choice here was based on these factors. We want to eliminate the physical resistance requirement. Okay? And also, the legislature thought it's not probative, or at least it's not determinative, since there are all these reasons why a victim might not resist. It's not a reliable indicator that there was consent. If we really want to get at consent, and that's what we're focused on, then either the presence or absence of physical resistance doesn't tell us much. Certainly the absence doesn't. The court says, look, if there is physical resistance, it would be probative of a lack of consent. But its absence doesn't tell us anything, or certainly not enough. Okay? So what is required? Mr. Williams.
I was going to say there was one more reason.
Which is?
Why it was eliminated. Well, just a practical legal reason that they wanted it to look more like assault, robbery, kidnapping, where that wasn't a requirement either.
Of course, then you get into consent. And why is that required? Right? But it's true that the court or the legislature and the court observing the legislature's reasons makes that determination. So what is required? What is required under this new formulation, Mr. Johnson?
I know intercourse is required, the act of sexual intercourse.
The act of sexual intercourse,
okay. Without non-consent?
I'm sorry?
And then non-consent?
And non-consent, that it be against a person's will and accomplished by force or fear of immediate and unlawful bodily injury. So you've eliminated the resistance requirement, but not the force requirement. You still have to have force. It just doesn't have to be manifested by resistance. So that's the California statute. And Kentucky has the same deal. We call it forcible compulsion, right? But it's force, the force requirement.
It says force for fear and not force and fear. So is force really required other than just the act itself?
Fear, but motivated by threats. And I would personally view threats as force. I mean, it's not physical force, but it's a kind of force. It's a psychological force. So I think you end up at the same place. So is it met here, Mr. Baker? These requirements, intercourse, non-consensual, by force or fear, is that met in this case?
Yes.
And thus is the conviction reinstated.
His verbal and non-verbal threats, like flexing his muscles, saying that he's going to expose his bad side if she tries to leave, that was the force and fear requirement.
And she communicated to him, the court says, or the jury could have found that she communicated to him her non-consent. She communicated that she didn't want to stay. She asked him to let her leave, open the gate, right, over a period of hours, and therefore, and his behavior constitutes the force or threats that induce fear on her part. What about the defendant's argument that she pretended to be a willing partner, and under those circumstances, the defendant can't know that it was non-consensual?
That's part of the frozen flight response. It says victim may smile, even initiate acts, and may appear relaxed and calm, but subjectively may be in a state of terror.
Why is this case a particularly bad one for the argument that that the non-consent has to be manifested? Right? Because defendants sometimes argue, look, I didn't know, and it was reasonable that I didn't know, because by all appearances, the complainant appeared to be fully consenting. Why is this case a bad case for that argument on the facts?
She had tried to leave multiple times.
Good. What else? Good. She tried to leave, and let's say, one problem with the facts is she kept telling him, I want to go. Let me go. So the idea that it was in fact not manifested is pretty weak. What else? Look at it from his point of view. Let's say she hadn't said any of that. Let's say she had simply responded with a freeze reaction, never saying a word as he went through his behaviors. Mr. Cannon, what would he say? What would you say is a weakness in his argument, even if he hadn't said a word?
I was going to point out the gate. I thought the gate was a factor in that she was kind of physically trapped there, but that's not what you're talking about.
Because she never gave affirmative consent.
Well, the requirement isn't affirmative consent under this defense argument. The defense argument is, I didn't know she didn't consent. If you were the prosecutor, what would you say here?
I would say because they were smoking pot that maybe her response isn't.
I'm not sure I want to bring that up as on behalf of my complaining witness.
If he says he didn't know, you can't assume.
Why would, under these circumstances, even giving his argument the best of it, why wouldn't he have known? If she had kept quiet, why wouldn't he have known? What gave rise to that?
I'm not going to give you the right answer, but
Take a shot.
she didn't give any, cues.
But why not? Even under his argument, why wouldn't she have given any cues or signals? Now, we know she did, but I want to assume for the moment that she hadn't. Why would she not, Ms. Call?
She didn't want to go there in the first place.
I'm sorry?
She didn't want to go there in the first place.
Yeah.
She was scared of them.
He did it. His actions put her in the position of freezing or not being willing to manifest non-consent, right? You can imagine some situations where this wouldn't be true, but in this case, the argument is incredibly weak because if she hadn't said a word, now she did, or at least the jury could have found she did, it was his actions that led her there. Once he starts saying things to which a reasonable person would respond by saying, I'm going to be quiet because I'm afraid, then he can't rely on the fact that he intimidated her into not manifesting non-consent as a defense. That would be a perverse outcome.
But wasn't his defense based on he said he didn't do any of that stuff?
Right, but the jury could have found he did.
Okay.
And once it found he did, he wants to also separately argue that she didn't manifest non-consent. And once the jury found he did those things, the only reason she wouldn't have manifested non-consent is because of his actions towards her. And we certainly don't want people to be able to benefit from intimidating their victims into silence. Okay? So that, as an independent argument, just really doesn't fly. Okay? I want to point you now to the model penal code formulation, which is on 943 and 44, and it is as ancient and out of date as you can imagine. 213.1, section 213.1 defines rape in one of four ways, or the circumstances that would make intercourse rape. The most important one, or the most common one, is the first. He compels her to submit by force or threat of imminent death, serious bodily injury, extreme pain, or kidnapping to be inflicted on anyone. So if you threaten the person, if you threaten somebody they know with I'll kidnap this person if you don't have sex with me, right? But it has to be force, and it has to be a very serious threat under the Model Penal Code, okay? So that is a very high standard.
Is the victim having, thinking the perpetrator is credible, relevant at all? Like, if I say I'm gonna kidnap whoever, or I'm gonna hurt whoever, and you
Including
don't
potentially
believe,
the
and,
victim.
yeah, and you don't, and it's not reasonable for the victim to believe me, is that?
Well, that's the question I thought you first asked is very different from the question you finished with. It's a big difference between did the victim actually believe it, and was it reasonable for the victim to believe it? Let me answer both anyway. Let's say the victim does believe it, right? And as a result, engages in the act of sexual intercourse in a way that is not meaningfully consensual, right? From the victim's point of view, there was this threat. The threat may have been to the victim, him or herself, or it may have been to somebody close to them. Whomever the threat was to harm, the threat was made. They believed it, maybe unreasonably, but it was honestly the cause of them engaging in the intercourse. I don't think we can say that was meaningfully consensual, right? So if I'm a prosecutor, I would not require that the belief be reasonable, merely that it be honestly held, because we're asking about whether it was truly consensual. And if it was honestly held, it wasn't. You could make an argument that if no reasonable person would have taken it seriously, right? And the defense can show a long history of joking between these two people, of making quote-unquote threats, but always meaning it in a kidding way, then the prosecution's gonna have a hard time explaining to the jury's satisfaction why did this person actually believe this one. And it's maybe not be credible that the victim actually believed it. So reasonableness, as you remember from the tax case, remember Cheek, the tax case, the airline pilot, we said the belief didn't have to be reasonable, it just has to be honestly held for willfulness on the defendant's side. And we said, but reasonableness is still relevant because the more unreasonable the belief is, the less likely the jury will find that it was in fact honestly held. So the more unreasonable it was, let's say it was unreasonable, for the complainant to think this threat was serious and genuine, the more the jury is likely to find, oh, wait a minute, I don't think he's even believed. That would be the way I would approach it.
So it's like if the defendant was saying, this was a consensual act, we've always joked about threats, you know, and.
That's a relationship I want no part of.
Right.
Joking about threats, I remember Elonis. The whole issue was what's a threat and what's a genuine threat. The defendant tried to argue, hey, I was not really threatening my ex-wife. That's a relationship that is troubled, to say the least. Yeah.
Why hasn't the Model Penal Code changed the language into saying, like, male homosexual intercourse will be while his wife? Like, why would they change that?
Well, the American Law Institute updates these codes, like the Uniform Commercial Code, the Model Penal Code, etc., the Uniform Probate Code. You'll get to that when you do trust in the states. All these codes are sort of these models for states to adopt or not as they choose. And they only update them every so often. They bring together all these experts, judges, lawyers, academics, the best experts in each field, and they only update them every so often when they feel there's a need. And there's been enough change in the area as a whole. And for whatever reasons, right or wrong, I have my own views on this, the ALI has not seen fit to reach the conclusion that there is a sufficient need in the area of criminal law generally to do a new update of the model penal code. I don't think anyone at the ALI would quarrel with the proposition that, looked at in isolation, the rape and sexual assault sections are badly out of date with contemporary trends in the law. But I think their position is that's not a sufficient reason to do a whole revamping of the code, of the model penal code as a whole, and they only do it as a whole. Yeah.
But didn't the FBI update their definition of rape back in like 2012 or 2013?
Well, the FBI doesn't have a definition of rape. The FBI goes based on enforcing federal law. So if I don't know the answer to that, but
Sorry, I meant the UCR, the one that reports all the statistics.
They may well have. I don't know the answer to that. But again, the question is about what the model penal code does. When the FBI or the Department of Justice compile statistics, national statistics, they do have a problem because every state law is different. And so they have to come up with some sort of definition to make everything uniform. And I'm guessing that's what Ms. Harper is referring to, and I don't know when they last updated that or what the current umbrella definition is. I am sure it is more useful as a mirror of or an indication of the current state of rape and sexual assault law than the model penal code is. Okay? Okay. Let's talk about Smith. So now we're going to take the next step in this reform story, and that is, should we eliminate not only resistance, but force as well? So tell me what happened in West Haven, Connecticut in March of 1987.
So the defendant or not the defendant, the plaintiff and her friend T and A were in a bar in West Haven.
Okay.
They were introduced to the defendant by a friend, and then A became friends with another person at the bar. They all went to dinner across the street, and then the defendant paid for the plaintiff's dinner.
I think he paid for all four, but certainly at least T.
Yeah.
At least T. And then the four of them left. And
Yeah.
what did the defendant suggest?
He suggests they all go to his apartment, and so the plaintiff's friend and then the other person at the dinner went and took the acquaintance's motorcycle to get there. And then
You said motorcycle, I hear. Is that what I just heard?
Wow. I didn't call that one. I thought sherbet.
You know, I have done that. It's pretty rare, and I imagine it's going to get more frequent as I get older and forget what I actually wrote in the envelope. But on those occasions when I've forgotten what's in there and call the wrong word, it's like the worst. I'm like, God, I feel like such an idiot. But not today. Not today, Mr. Milwaukee. Don't do that. They left the acquaintance and A and the other guy left on the motorcycle. Smith gave them directions. They never showed up. But Smith and T walked, and they arrived there at about 10 o'clock. Okay. Take a chance here, see how you guys react. Every year. Okay? Smith has bought T dinner. T has agreed to go back to his place. The men in the audience, the men in the class, what are you thinking at this point? What do you think most men, if not you individually, are thinking at this point? You're not a guy.
I know what they think. One of them has to be brave enough.
I believe the guy thinks he's going to have sex.
He has scored. He hasn't scored, but he believes she's agreeing to come back to my place, that means only one thing. Sex. We're going to have sex. Okay? Any guys want to dispute this? Not a single, Ms. Clemens?
She agreed to come back with a friend of hers and another guy though, not solo.
I think there's circumstances. You gotta feel it out. I mean, you know, if she's like, if it seems like that, then you can believe that. But I don't know if just dinner first. Well, I don't know. They were at the bar though.